1,723. These are the number of judgments currently outstanding from the country's 26 superior courts during the fourth term of 2024. This, however, is a slight decrease from the previous term, with the courts managing to shave off over 100 judgments from their backlog. Senior justices believe the picture is not as bleak as it looks.
The judgments reserved for less than 6 months includes a judgment that was, for example, reserved a day or two ago or even a week ago.
But there are still 233 judgments that have been reserved for more than 6 months. This despite the judicial norms and standards dictating that efforts should be made to ensure that judgments are handed down in a period not exceeding 3 months. The Gauteng division has a substantial contribution to this figure, as Pretoria has 55 outstanding judgments and Johannesburg has 7.
There haven't been an increase in the number of judges across all courts since 2009. So for the last 15 years, we've had 250 judges and that number has not increased. But during that same period, if you look at Gauteng, for example, the population of Gauteng between 2009 and 2025 has increased by more than 50%. And that means that the volume of cases that come to the Gauteng High Court have also increased because of the volume of people who live there, the complexity of the economy, the violent nature of the crime, and the increase in the crimes that come to the courts. That also impacts on the volume of cases that come in. So what we're seeing is that we have fewer people doing more work over the last 15 years. And that's why we're seeing the judgments taking longer to be delivered. And that's why they understanding those constraints, they thought it's reasonable to say that there must be 6 months that is set as sort of when you get into trouble as a judge for not delivering a judge. We don't think that 6 months is acceptable. It's not the solution is to increase the number of judges that are in the court. That is the way that you do so. You don't solve a problem by dropping standards.
But what is the judiciary doing to alleviate the backlog? In the Gauteng division, former Judge President Dunstan Mlambo introduced compulsory mediation in an attempt to ease the caseload. However, this is not a policy of all courts.
All courts currently have pre-trial conferences. And at that conferences, we try to make sure that the parties identify the issues that they actually want to submit to a court for determination. Instead of just submitting a case to the court and presenting a lot of evidence, calling many witnesses, at the end of the day, it then becomes clear that this whole case actually turned around a very crisp issue that could have been resolved had the parties applied their mind properly to the case.
The issue is from top to bottom. The Constitutional Court has 8 judgments it's reserved for more than 6 months. This despite being the apex court that should lead all other courts in the country. The highest court in the country has not had a full complement of justices since 2016. According to the Judiciary Report for the 2022-23 financial year, then Chief Justice Raymond Zondo said the court had set a target of 70% to resolve matters before it, but only achieved 55%.
The Constitutional Court took the position that in order for it to properly discharge its obligations and perform in an acceptable way, it will be necessary for an amendment to be made to the Constitution so that it is able to dispose of a number of matters without every justice having to take part in every case. Because at the moment, the constitutional requirement that the justices of the Constitutional Court should sit and bank means that if there are 300 new applications that come in, every justice serving at the court at the time should take part in deciding all those 300 cases.
Among those pending is the Phala judgment that has not formed part of the fourth term of the court but has been outstanding for almost a year, having been heard in November 2024.
Yes, that's true, Zoleka. It's not the ideal situation. I will agree with you there. But as I explained to you, the processes of the Constitutional Court differ vastly from the processes in the other courts. Like the other courts, the Constitutional Court also has other matters to deal with. For example, applications for access to that court and other matters. And they also sit in other matters. All 11 of them will, for example, in term, sit at least twice a week dealing with matters, uh, complicated matters, obviously. So it might just be, and I don't know the specifics of this case, and I do not want to discuss the specifics of the Phala case, but it might just be that there are judges who are at this stage inclined to disagree with their colleague or who have already indicated their disagreement and might want to write a dissenting judgment.
But such delays in the administration of justice do not bode well for trust in the judicial system.
The fundamental pillar of the rule of law is speedy resolution of disputes. The faster you are able to resolve disputes that come before the courts, the more confidence that people have in the courts. And the opposite is true. If you take too long to resolve disputes, then people don't have trust and faith in the courts. People either will avoid taking their cases to court, they'll take the law onto their own hands, but it also has an economic impact. Like if I'm a foreign investor and I want to invest in South Africa, I want to be guaranteed that if I ever have a dispute with any other business, it will be resolved as quickly as possible. And unfortunately, because these disputes, these cases take long to be resolved in the courts, that also has an economic impact. People are reluctant to invest.
The implications for ordinary people may be just as dire.
But even on the ground level, people being able to somewhat feel that even bringing a matter, maybe criminally or even civilly, like maybe hesitancy, somewhat you've maybe heard people say, what's the point? I know that X and X is going to happen. What's the point? So some of those consequences sort of have people deviating and creating a third alternative, somewhat judicial space, judicial framework where they can have their issues resolved. Because conflicts aren't new. We're human beings, we've been alive for a long time. We've always dealt with conflicts, but somewhat within the current sphere that we're within, people are somewhat beginning to leave the current, so somewhat like the balances, somewhat the rules and the values that are also able to guide the society to find their own recourse. So it is quite damaging, and somewhat people sort of finding their own way, creating a third way in terms of navigating justice.
Musi adds that there are several other contributing factors leading to the delayed judgments, but emphasizes that it would be incorrect to conclude that it is due to incompetence. For Newzroom Afrika on Channel 405, I'm Zoleka Qodashe in Johannesburg.